We're diving into a battle between a single property owner and their homeowners association. And really, it's a story about rules, rights, and a bill so out there it sparked a legal fight that went on for over a year. So here's the central question, and it almost sounds like a riddle, right? Can your HOA slap you with a move-in fee when your new tenant shows up with, like, a single briefcase and nothing else? It sounds like it should be a simple question, but the answer turned out to be incredibly complicated and really, really expensive. For one owner, this wasn't just some hypothetical thought experiment. No, he was looking at a bill for over $5,000 in fees and penalties, and it all stemmed from that one simple, frustrating question. So he decided to fight it. Okay, so how does a disagreement like this blow up into a full-blown legal battle? Well, it all starts with a bill that, when you look at it, just doesn't seem to make any sense at all. Here's the situation. We've got a fully furnished condo in Arizona. It's often rented out for shorter-term stays. Now, for every single new tenant, the HOA was charging these big move-in and move-out fees, even though nothing, no furniture, no boxes, was ever moved. The only thing these tenants were bringing was their own luggage. The owner looked at these charges and thought, this isn't just unfair. He was actually convinced it was illegal. And that's when he decided to take a stand and fight back. So the owner, a guy named Jonathan Blangiardo, takes his case to an administrative law judge. And his core accusation was this. He believed the HOA was basically weaponizing these fees to specifically target and punish owners like him who rented out their units. And in court, he really laid it out there. He argued this wasn't just about one random fee. He claimed it was a deliberate, ongoing pattern of misconduct from the HOA board, designed to make it as difficult as possible for rental owners, with these fees being their primary weapon. So let's actually break down the numbers here. It was a $150 move-in fee, a $150 move-out fee, plus a $25 registration fee. You do the math. That's $325 for every single tenant. Now, if you've got a unit that rents month to month, you can see how that adds up to thousands of dollars a year, easy. His case was really built on a few key points. First, he pointed to a specific Arizona law that he argued made these fees flat out illegal. Second was just the simple common sense fact that no actual moving was happening. But his real smoking gun? He got his hands on internal HOA emails where they literally called the charges rental fees. He used that to prove their intent, and when he refused to pay, well, the HOA came down on him, cutting off his access to the pool and even taking away his right to vote in the community. But, every story has two sides. The Homeowners Association came back and argued that their fees were perfectly legal, totally necessary, and were being applied fairly to absolutely everyone. And this really gets to the heart of the whole conflict, doesn't it? For the owner, this was an illegal penalty designed to punish him. But for the HOA, this was just business as usual, a standard administrative cost to cover the work it takes to process any new person moving into the building. Now, to really get the HOA's argument, you've got to understand the CC&Rs. The best way to think of these is like the constitution for that community. It's a binding legal contract that every single owner agrees to when they buy their property. It's where the HOA board gets all of its power. So the HOA built its entire defense on those CC&Rs. They argued the fees weren't discriminatory because they applied to everyone moving in. Didn't matter if you were an owner or a renter. They said the money covered real costs, staff time, programming new key fobs, that kind of thing. And most importantly, they claimed the CC&Rs gave the board the power to create these fees in the first place. And as for locking him out of the pool, they said his whole account was past due, not just these specific fees he was fighting. And the HOA's lawyer basically boiled their whole strategy down to this one really cutting point in court. She basically framed the owner's case as being about his feelings, about what he felt was fair. But she argued that the HOA was simply following the law and its own governing documents, and that that's the only standard a judge should care about. So with both sides completely dug in and refusing to budge, this whole dispute turned into a legal marathon. I mean, it dragged on for more than a year. The whole legal battle played out right here at the Arizona Office of Administrative Hearings. This is a special kind of court designed to handle these exact types of disputes. Fights between regular citizens and state-regulated groups, which, yes, includes HOAs. And this timeline just shows you how grueling this process really was. The case got delayed again and again. The first actual hearing didn't even happen for 9 months. For over a year, it was just this slow, painful grind of legal motions, status updates, and continuances. And this really shows you the tough reality of these situations. Fighting an HOA, even over what seems like a small fee, is often a war of attrition. It just takes an incredible amount of time, patience, and paperwork to see it through to the end. So, after more than a year of legal filings and heated arguments, what was the final verdict? Well, this might be the most surprising part of the whole story. You see, the official court documents, which are the source for this whole story, they just end. There's no resolution. The final hearing concludes, the judge says a written decision will come later, but there is no verdict on record. The case file just goes cold. So without a clear winner, what's the takeaway here? Well, the story kind of stops being about who was right or who was wrong. It becomes about something much bigger, that fundamental conflict that's at the heart of every single HOA, the constant tug of war between an individual owner's rights and the community's power to make and enforce its rules. And it leaves us with one final critical question. This whole case started with a simple bill for moving nothing, but it ends by forcing every homeowner to take a hard look at the contract they signed when they bought their home. It makes you ask yourself, what power have you actually given to your neighbors, and what rights did you sign away the moment you were handed the keys?